Okay, let's visit for a while to the background of Presidential Decree 442. You will understand that prior to the issuance of PD 442 on May 1, 1974, all labor laws were scattered and they were just consolidated under PD 442. So the significance of the effectivity of PD 442 is this. During the implementation of PD 442, there was this 3-year limitation on back wages. However, when Republic Act 6715, a major amendment to the Labor Code, after March 21, 1989, there is no more limit to the award of back wages in cases of illegal dismissal. So it will be from the time the employee was deprived of the wages due to illegal dismissal up to the finality of the decision. So the reckoning point is March 21, 1989. Let's go to the next topic on the basis of enactment of labor laws. First, we will go back to the power of the state, the police power of the state, as enunciated in the case of Philippine Association of Service Exporters Incorporated versus Drilon. According to Supreme Court, Department Order Number 1, which imposes temporary suspension deployment of ban of Filipino domestic helpers abroad, was a valid exercise of police power. So I discussed that the nature of social legislation is that it is a product of exercise of police power. So this is the reason why we consider that as a basis. Another basis for the enactment of labor laws would be the social justice and the social justice and human rights provision of the Constitution. You can find that in the whereas portion. Section 18 of the Social Justice Clause, Article 2 of the 1987 Constitution. According to that provision, the state affirms labor as primary social economic force, and it shall protect the rights of workers and promote their welfare. Then, Section 3, Article 13, the state shall afford full protection to labor, local and overseas, organized and unorganized, and promote full employment and equal employment opportunities for all. It guarantees the right of workers to self-organization, collective bargaining agreement, and to engage in peaceful concerted activities, including the right to strike in accordance with law, and etc. So if there is a labor law enacted by Congress, then you can find that in the whereas clause, the social justice and the social justice clause provision of the Constitution. Another basis for the enactment of the labor laws would be the Doctrine of Incorporation under Article 2 of the 1987 Constitution, Section 2 more specifically. So, using your knowledge in constitutional law, we learn that this provision of the Constitution provides that the Philippines, other than renouncing war as an instrument of national policy, it adopts the generally accepted principles of international law as part of the law of the land, and adheres to the principle of peace, equality, justice, freedom, cooperation, and amity of all nations. So, being an adherent to generally accepted principles of international law, the relevance of pacta sunt servanda will come in here, because we have treaty stipulations, treaty agreements with International Labor Organization, and this will be the source of our laws, particularly labor legislation. That's why we cited that, the Doctrine of Incorporation. Let's go to the limitations in the enactment of labor laws. First would be the Equal Protection Clause in the Constitution. So meaning, we learn in your constitutional law too that in order to comply these constitutional requirements, if you are going to classify persons and give special privilege or protection, there must be a valid classification. That's the Equal Protection Clause. Just like the Migrant Workers Act, it protects the migrant workers, so it's a valid classification. So if you do not pass this test, if there is a law And I think it's also applicable to other legislations. It will become unconstitutional and it will be declared by the Supreme Court as unconstitutional. Another one would be the due process clause of the Constitution. If there is taking of property of the employer, money of the employer, that cannot be done if the law will not provide the compliance of due process. So before you make the employer pay for whatever money claims that the employees are entitled, you must observe due process, no matter how guilty the employer is. Another limitation in the enactment of labor laws would be the prohibition against involuntary servitude as provided in Section 18, Paragraph 2 of Article 3 of the 1987 Constitution. So what is the relevance here? It means that the employee cannot be compelled to be engaged in perpetual employment. So the employee can therefore resign. So there can be no legislation that can be passed by Congress stating that the employee cannot resign because it is tantamount to involuntary servitude. However, it will not prevent the employee from entering into a contract or what we call the lock-in period, because the employer entered into a contract where the employee entered into a contract with the employer where the employer spent for training of the employee, and they entered into a lock-in period of, let's say, 2 years in the case of Flores vs. Court of Appeals, January 21, 2004. It doesn't mean that even if the 2-year period has not yet lapsed, that the employee cannot resign. If the employee resigns within the 2-year period without any valid reason at all, or meaning there's no fault of the employer, it doesn't mean that the employee cannot resign. The employee can still resign, but subject to liability for damages due to breach of contract. On the other hand, if the employee resigns within the 2-year period because of the act committed by the employer, for example, act of sexual harassment leading to constructive dismissal, then you cannot fault the employee from resigning, and there will be no liability for damages. But in all instances, this prohibition against involuntary servitude means that the employee cannot be compelled to perpetually stay with the employer until he or she dies. So there's no such thing as perpetual employment. Another limitation would be the non-impairment clause of the Constitution. When can we say that there is impairment? According to the Philippine Amusement and Gaming Corporation versus Bureau of Internal Revenue, March 15, 2011. There is impairment if a subsequent law changes the terms of the contract between the parties, imposes new conditions, dispenses with those agreed upon, or withdraws remedies for enforcement of rights of the parties. So let's bring this case to the contract entered into with the employer and the employee. If there is a contract already signed by the employer and the employee, and a subsequent law is passed by Congress changing or modifying the terms and conditions of the contract, then it violates the non-impairment clause. However, there is an exception. If the passage of the law is a product of police power, then the non-impairment clause will not prevail. Another limitation would be the requirement of publication. So any labor legislations, implementing rules and regulations affecting the public, it must be published in the newspaper of general circulation or in the official gazette. If you look at Article 2 of the Civil Code, it only provides official gazette. That was the case of Tanyada versus Tubera. However, during the time of Cory Aquino, Executive Order 200 was passed. Because of the unavailability of official gazette to the general public, this Executive Order number 200 now provides that publication can be done in official gazette or in newspaper of general circulation in the Philippines as a requirement for its effectivity. So unless the law, or unless any labor law or department order is published before a newspaper general circulation, then it will not become effective. Okay, let's go to the next topic of labor applicability. First, we have to start with the basic premise that there is employer-employee relationship, because if there is no employer-employee relationship, the labor code will not apply. And the labor code will apply also to non-stock, non-profit entities or establishments. So even if you belong to a religious organization or corporations, as long as there is employer-employee relationship, then the labor code will apply. Take note also of the exceptions of the coverage, especially those entities cloaked with diplomatic immunity. So you cannot apply the labor code of the Philippines. In case of religious corporations, or between, let's say, a pastor of an organization or religious organization, you have to clarify. First, check if there is employer-employee relationship between the two. Because they will allege that the labor code will not apply if a pastor is terminated by the church. If there is a contract, an employment contract, then that is a good evidence to show that there is employer-employee relationship. If it is purely a matter of faith and church doctrines applied and it resulted to transfer of pastor, then the labor code will not apply. Remember the fourfold test, no? If there is employer-employee relationship, then we rule the labor code will apply.